And you were asked to render an opinion regarding a psychiatric diagnosis and legal insanity, correct?
That is correct.
And the opinion that you're asked to form is not as to his his mental condition today, but his mental condition on November 18th, 2010, correct?
That is correct.
So his current mental state is not directly at issue.
Well, whenever I conduct a forensic psychological evaluation, especially for criminal responsibility, I need to understand three different mental states in time. I need to understand their mental state at the time I see them to know if they're competent to do the evaluation. I need to know their mental state across the lifespan to see if they've had symptoms of a psychosis or other mental illness, but most importantly, their mental state at the time of the crime.
So his condition now is relevant to the diagnosis, even though it's not relevant to legal responsibility.
That is
correct. Do you
correct.
agree with that? And you interviewed Mr. Neuman on June 30th, is that right?
Yeah, that's right.
And that was for 3 hours and 20 minutes?
Correct.
And that was just over a month ago, correct?
That is right.
And you had never met him before that day?
In 2011, when I was coordinator of outpatient forensic evaluation services.
I'm sorry, Your Honor. May we approach briefly?
Sure, come on, Glorious. Ms. Sampson.
Your Honor, I'll withdraw the question.
Question withdrawn is up to me to respond to. Next question.
So when you met with him this June, that was close to 6 years after the shooting, correct?
That is correct.
And you only met with him once? You didn't go back to do any kind of follow-up?
That is correct.
And you never contacted him in any other way to see if there were things that he had thought of that he didn't share with you, or to follow up on any of the information you were given after the interview?
That is correct.
Follow up on any of the information you were given after the interview?
That is correct. I integrated the interview information with the information I had from the discovery.
When you went out to see him, was he cooperative?
He was.
And he knew that you were there for forensic evaluation?
He was aware I was coming, yes.
And you told him that anything he told you would be shared with the court and with the district attorney?
That is correct.
And he went ahead and talked to you?
Yes, he signed the advisory notice after I reviewed the information with him.
And he went ahead and talked to you?
Yes, he signed the advisory notice after I reviewed the information with him.
Now we're talking about some of the definitions here. If someone is bipolar, they are not going to be manic all the time, correct?
People with bipolar disorder have the manic episode for at least a week's duration.
Okay. So the episode, the manic symptoms could have lasted for a week. They wouldn't have necessarily lasted throughout this time period that we're talking about, correct?
The course of bipolar disorder varies from individual to individual. Some have rapid cycling where they have a week's episode and come back into depression and go back. Some have manic episodes that last for months or years.
Okay. And you can actually go years between episodes, correct?
People can.
If his major symptoms were psychotic features, if his major symptom was delusion, that is not a symptom that casual observers or co-workers would necessarily have noticed. Would you agree?
Well, if you're describing something called a delusional disorder, where delusion is the only symptom, that might be true. That is not the definition of bipolar disorder manic with psychosis. With bipolar manic with psychosis, the delusion occurs only in the context of the mood symptoms.
But you could be delusional and not be showing all of the full manic symptoms, correct?
That is not correct with bipolar disorder.
Now, in the definition for manic, where it talks about whether the mood disturbance is sufficiently severe to cause marked impairment of occupational functioning or to necessitate hospitalization to prevent harm to self or others, it also says, or there are psychotic features, correct?
That is correct.
So that's implying that you do not have to have marked impairment if there are psychotic features, correct?
The definition is misleading because if someone is in an acute manic episode with agitation, with expansively high mood, even if they have psychotic features, that may affect their occupational and social functioning. So it's listed as an or, but there is a qualifier in that the person is going to show some symptom to somebody.
Okay. So you would agree that the definition, it is listed as an or.
Yes.
And so in your opinion, essentially the definition is wrong. It has to be both.
I'm saying that observing people with bipolar disorder for the past 31 years, I recognize them when I see them.
But according to the DSM, you only have to be manic for as short a period as a week to have that diagnosed as a manic episode,
That is correct. And the psychotic episodes occur in the context of the mood symptoms, depression or mania.
And someone who is delusional is not aware that they're delusional, correct?
That is correct.
And isn't it true that according to the DSM, when a person is delusional, they can appear normal when their delusions are not being discussed or acted on, correct?
That is only true for delusional disorder. That is not true for delusions associated with bipolar or schizophrenia. That's a completely different chapter of the book.
And in that chapter, in the chapter regarding the delusional disorder, isn't it true that according to the DSM, when a person is delusional, their behavior is neither odd nor bizarre unless they are acting on the delusion, correct?
That is true for delusional disorder.
And for delusional disorder, isn't it true that when a person's delusional, their psychosocial functioning is not markedly impaired, correct?
For delusional disorder, that would be the definition.
And by definition, if you are delusional, that is or by definition, the presence of psychotic features during a manic episode satisfies criterion C, what we were just talking about, correct? By the definition, not
Well,
by your...
Again, if you look at the DSM, and they have the description of delusions, hallucinations, other psychotic symptoms, these are general definitions. Beyond that, you're describing what I remember from the chapter on delusional disorder. That's a completely different disorder from bipolar disorder, manic with psychosis. So you can't superimpose those two diagnoses. You have to stick to the actual diagnosis at hand. Otherwise, you're using a different diagnosis.
Now, when you were talking about the diagnoses, or the two ways that you can be found not guilty by reason of insanity, there is a code section specifically for delusions, correct?
Delusional compulsion, that is correct.
But for delusional compulsion, it has to be a compulsion that, basically a delusional compulsion that, if true, would be a defense. So, for example, that I am in danger from this person, and it's in self-defense, even though we know because of the delusion that it's not actually true.
That is correct. Case law established that component of the delusional compulsion prong, yes.
So if you're going to malinger, if you're going to fake delusions, it would make much more sense to say that you believed that you were in danger, that you believed the person was a danger to you than to someone else that would not qualify for that definition, correct?
I object to that question. Give it cause for speculation.
Sustained. Yes, sustained.
Would you agree that persons with traumatic histories who have never been in therapy or really discussed the trauma can experience a surge of emotions that can be very stressful upon first really discussing the trauma? So the first time they discuss the trauma.
Well, persons who have experienced trauma can have emotional reactions when discussing or remembering the trauma that would be consistent with post-traumatic stress disorder or acute stress disorder, depending on the time frame. But again, that's another diagnosis.
And if they're not able to process that new information in a healthy manner, that can lead to depression, or, as you said, the post-traumatic stress disorder, or even loss of touch with reality, correct?
People who have been exposed to trauma can experience those things, yes.
Now, you talked about the records that you reviewed, and that was all in June of this year?
Yes.
Do you have an idea of how many hours you've put into this case, into preparing?
By the time I saw Mr. Neuman, I had spent about 120 to 150 hours reviewing the material. After I saw him, I spent additional time reviewing additional material and integrating that into a report.
Okay. And then you spent 3 hours and 20 minutes with him?
Correct.
Now, you didn't yourself interview any of the people whose statements you were given, correct?
That is correct. I listened to the audio tapes of those interviews.
And you didn't interview anyone who knew him as a child?
No.
And you didn't interview anyone who knew him in 2008?
No.
And you didn't interview anyone who knew him in 1998?
Correct.
You didn't attempt to interview his sister or his mother or his aunt or any other relatives?
No.
You didn't try to interview his ex-wife?
No.
You didn't try and interview the woman that he was living with at the time of this incident?
No.
You didn't try and interview Andrea Sneiderman?
No.
And you didn't interview Lori Jerkovic?
No.
Did you talk to any of the doctors that treated him at the treatment facility where he was between when he left the DeKalb jail and 2015 when he came back?
My understanding is the treating doctor is deceased, and I reviewed all of those records that I had.
Okay. Well, there were multiple therapists that saw him, correct?
There were many therapists, but the doctor who prescribed his medications, I understand, is deceased.
Okay. Did you attempt to contact any of the therapists?
No.
If you had been able to verify through witnesses the depressive episode at the boarding school?
Not. In my review of the symptoms reported in that time frame, they were not consistent with bipolar disorder.
You say the symptoms were not consistent with bipolar disorder, but you didn't speak with anyone that was around him other than briefly with Mr. Neuman, correct?
With Mr. Neuman and a review of the information he provided to others.
You say the symptoms were not consistent with bipolar disorder, but you didn't speak with anyone that was around him other than briefly with Mr. Neuman, correct?
With Mr. Neuman and a review of the information he provided to other evaluators.
If you had verified a manic episode where he ran up over $100,000 in debt in just a few months, was doing extensive day trading, extensive hundreds of $1,000s in investments over a very brief period of time when that had not been true in the past, was sleeping maybe 2 or 3 hours a night, was extremely irritable, was there were changes in his behavior. If you had been able to verify that episode, would that have changed your diagnosis?
It would not necessarily change the diagnosis, and certainly wouldn't change my opinion because those did not occur at the time of the crime.
But if there was a previous manic episode, that would affect whether or not he was bipolar, correct?
If someone has had at least one verifiable manic episode, that would generate a diagnosis of bipolar disorder. But again, in my review of the information, I could not find objective evidence that he had bipolar.
Were you provided with any financial data from that time? Were you aware of an incident where he was going to quit his highly paid engineering job and go to school to become an airplane pilot?
Yes, he discussed that with me.
Did you take any steps to find out more about that incident or to verify that incident?
Well, he has a degree in aerospace engineering, so it's not uncommon for people with that background to have an interest in things that fly. Wanting to be a pilot is just a hobby that he might have wanted to explore. I didn't find that unusual.
But he was talking about quitting his job and becoming a professional pilot when he had never flown before. That is different from choosing to take up a new hobby. Wouldn't you agree?
Well, still, it's not evidence of bipolar mania.
Were you aware of a period when he was in college where he appeared to sleep all the time? He was unable to go to class, unable to get work done, where his grades dropped significantly, where he went from being an excellent student and active in a fraternity, volunteering, doing social activities, to basically not leaving his room, not doing anything, and where he spent a summer basically refusing to move off the couch. Would all of that be consistent with depression?
That could be consistent with depression.
Now, when you interviewed him, you didn't ask him, or did you ask him about any episodes where the angel appeared to him after his arrest while he was in custody?
He did not mention any episodes afterwards.
Did you ask him specifically about any other episodes after his arrest?
I asked about times that he had seen demons and angels.
Did you press him, though, about whether there were any additional episodes with either the demon or the angel after his arrest?
Well, the focus of my examination is most importantly on his mental state at the time of the crime. He reported no hallucinations on that day.
Now, while we're talking, while you just brought up hallucinations, the attorney.
Can vary, and people can have a later onset of bipolar disorder.
But it's not unusual for someone to have seen symptoms in their life, but not to actually be diagnosed or treated until later, correct?
Some people go untreated if they have a milder form of bipolar. With bipolar 1, an acute manic episode, people would notice something is wrong.
Now, you reviewed the treatment records starting from when he was first arrested, correct?
Correct.
And you were aware that he was in psychotherapy for bipolar disorder from 2013 until 2015.
I read those records, yes.
And you were aware that he's been on 2013 or 2012, correct?
Correct.
Now, you reviewed Dr. Flores' testing, correct?
I reviewed his testing, yes.
Okay. And that was done in 2011, close to the time of the incident, correct?
Well, that was done in September 2011. The incident was November 2010, so about 10 months apart.
Okay. And she did. And to your knowledge, the cutoff for malingering on that is.
Looking at the whole picture.
But you're aware that there were suicide attempts, correct?
Yes, or reported suicide attempts. He avoided each one.
And he's not saying that he always obeyed the commands, correct? I mean, he qualified that. He said, I think about it, but I might talk them out of it.
Well, as Dr. Flores scored the test, she marked that item as a 1, so he was endorsing that particular item.
Right. Well, if she had marked that as a 0, then his score would have been 1 rather than 2 and still not malingering, correct?
Well, it wouldn't say not malingering. It would say it would not trigger further assessment.
Okay. So the fact that she listed that as a point rather than not a point was being more conservative rather than marking it as 0 and giving him a lower or a score that would indicate less malingering, correct?
I have seen people malinger who score in the normal range on malingering tests and other psychological tests.
Okay.
So
But
no test is foolproof in assessing malingering.
Sure. I mean, a single test doesn't decide the issue, but on this test, this screener, it did not indicate any need to go further in testing for malingering. It did not indicate malingering.
The
Correct?
raw score would not trigger further testing, but again, the response is irrelevant.
And as to the second question about he had been afraid of leaving his house or room when he was hearing voices, that was also checked as sometimes, correct?
As I recall, yes.
Now, if he had, in fact, tested over 6 rather than 2, that would indicate that you should go on and do additional testing, correct?
Correct.
And, in fact, she did go ahead and do the Sears exam, even though it was not indicated by that test, correct?
Well, frequently forensic psychologists will use the SIRS if people may be suspected of malingering psychosis. It's a standard instrument to use in those cases.
Okay. And that's basically the gold standard test for malingering, correct?
Well, I don't know that any test is a gold standard of anything. It's the most commonly used test for that purpose.
Okay. And you've used that test before?
Many times.
And on that test, he fell within the honest or the indeterminate range on all 8 of the scores, correct?
That is correct.
And his total score was a 51, which was also below the cutoff of 71 for malingering, correct?
If you're looking at the scores, but the fact that he had some items in the indeterminate range is relevant.
Now are you familiar with the manual for that exam?
Quite familiar, yes.
Okay. And would you agree that the manual says many bona fide clients will have most of their SIRS scales in the honest range and the several remaining scales in the indeterminate range? Some variability among scales should be expected for honest responders, correct?
That is correct.
And his score, his overall scores were well below the cutoff.
That is correct.
And he didn't have any score that was in the, I'm sorry, wait, go ahead. He didn't have any scores that were in the 2 sections for malingering, correct?
That is correct. But I have seen people score in the honest range on all 8 scales and still be malingering.
Okay. But the results of this test, you would agree, were non-malingering.
Well, again, the test was not in the definite or probable range. No test can definitely say someone is not malingering. You have to look at all information in its entirety.
But the result of this particular test.
That particular test would not suggest malingering.
Now, she also gave the MCMI-3, correct?
The Milan Clinical Multi-Axial Inventory, yes.
And in that test, there was no indication of over-reporting, correct?
Well, there are serious problems with the use of the Milan. Most forensic psychologists do not use that in forensic psychological evaluations. The test is only 175 true-false items. The validity indices of the test, that is, those that tell us that people are responding in a certain way, according to Richard Rogers' book, Assessment of Malingering, only have an accuracy rate of about 0.59 to 0.79. So that means the validity scales are inaccurate 20 or 40% of the time.
Okay. So you would not use that test to diagnose someone?
For a forensic evaluation, I would not use the Milan.
But it certainly, if someone is underreporting as opposed to overreporting, that is additional information to take into account along with the previous 2 tests that we talked about.
Well, the Milan
correct?
has a base rate cutoff of 74 on the test. None of his validity indices were above 71. So nothing on those validity scales would tell me anything. So underreporting, if that were happening, would not be suggested from that score of 71. It's below 74. So she was inaccurate in her description there.
Wasn't his score for bipolar 85?
That was the score. However, the test only has 13 questions related to bipolar manic. So certainly with only 13 questions, endorsing things like I have a lot of energy sometimes, 74. He had scales that were greater than 74 on the clinical scales. The highest, of course, was narcissistic at 100 and something.
Now, you did not do any of your own testing, correct?
That is correct.
And if you thought he was malingering, why not try and get some objective measure of that?
Well, first of all, he had been tested twice before by Dr. Flores and Dr. Marks with the SIRS. And I know from doing thousands of psychological evaluations, people who malinger, who are smart, know how to malinger on malingering tests. They know that if they hear a bizarre symptom, they're not going to endorse it. So there was no need to do further testing.
But certainly if he had tested as bipolar after all of this time of treatment and on medication, that would tell you something, correct?
It would tell me nothing about his mental state at the time of the crime, which is what I was ordered to evaluate.
Right, but you give an opinion as to his diagnosis, correct?
That is correct.
Now, when the state was talking with you earlier, you said that he did not describe a delusion on the day of the crime, but he did describe that the delusion that he believed the children were in danger and that it was his duty to protect them, correct?
He discussed having that belief in August.
And he said that that was an ongoing belief at the time of the incident, correct?
Mm-hmm.
Now, you talked about his description of the demon as being huge. He never gave to any of the doctors a specific height or a specific description of how tall the demon was, correct?
As I recall in Dr. Crawford's interview, when she saw him at the jail, he described it about as tall as the ceiling. She estimated that to be 12 feet in the room she was using for the interview.
And you would agree then in all of the hallucinations that Mr. Neuman described with the demon, he was sitting, correct?
He was driving his car, he was sitting, that's correct.
Okay. And the other incidents as well? I say, and the other incidents as well?
Yes.
You talked about his descriptions of the voices, and you said that he told Dr. Crawford that, I think you said that he told Dr. Crawford that the angel sounded like Olivia Newton-John, correct?
That is what was on the tape, yes.
He didn't actually say that she sounded like Olivia Newton-John. He said that the voice was similar, and she in fact followed up and verified, no, this is not, she didn't have an accent, she didn't sound like Olivia Newton-John, correct?
Well, as I recall from the interview, he was describing the actress in Grease, and Dr. Crawford brought up the name Olivia Newton-John.
Okay. But then she specifically followed up, did she have the accent?
Right.
Did she sound like that? And it was, he was talking about the voice itself, correct?
Correct.
Now, you talked about no one at the jail noticing hallucinations. He didn't tell you about any hallucinations at the jail, correct?
Correct.
And if he was not hallucinating while he was at the jail, if he was not in a manic episode at the jail, then they wouldn't have. If he was between episodes, there would be nothing to see, correct?
That is correct. He was there for some time, so I would expect that he might have shown some symptoms over the course of that time.
But in fact, in his description of his history, there were years between episodes, correct, in the past?
Yes, but when questioned by mental health personnel, he denied symptoms of hearing things, seeing things.
Okay. But if he was not symptomatic, he wouldn't be hearing things or seeing things, correct?
But those are questions asked about one's history.
The intake sheet is asking about current symptoms, correct? Not past.
Right, and then the mental health staff who see them while they're in the infirmary would collect the additional information. He was there in the mental health infirmary for 3 months, I think it was.
Okay, I have no further questions.
Any redirect?
Yes, I have one moment, Your Honor.
You may.
Thank you.
Any redirect?
Yes, Your Honor, briefly.
Oh, ask as many questions as you wish. Nobody's limited.
Thank you.
Dr. Huey, you told Ms. Sampson when she asked you that you've seen people who are malingering not score malingering on the test. Explain to the jury how that happens.
Well, tests of malingering, I can't tell you too much about that since they're copyright, but they may ask questions of bizarre things like how many toes does someone have, or do elephants fly? People who are intelligent recognize that's bizarre and are going to not endorse those tests. So it's somebody who is only malingering a symptom of, say, a psychosis, or only malingering a symptom of a cognitive deficit, will know not to endorse those items. So it's possible for people who are malingering to still not score positive on a malingering test.
In your interaction with the defendant and your review of the information that you discussed with the jury, did you find the defendant to be of average or above average intelligence?
Certainly, he has a degree in aerospace engineering. He worked as an operations manager. He has above average intelligence based on his vocabulary and presentation on the interviews. So he's a smart man.
And are smart people better situated to malinger or to fool the malingering test than people who are less intelligent or educated?
Certainly.
Ms. Sampson was asking you about questions about delusional disorder. Do you recall those questions?
I recall.
Okay. To your knowledge, has anybody diagnosed this defendant as having delusional disorder?
They have not.
Is delusional disorder a different mental diagnosis than bipolar 1 with psychosis?
Yes.
Explain to the jury why that's different.
Well, delusional disorder, by definition in the DSM, is someone who has a delusion, but that's the only symptom of psychosis they have. So they may go to work, they may have relationships. Unless you're talking about the delusion, that group of people may appear normal. However, with bipolar disorder mania with psychosis, the psychotic symptoms, such as delusions, hallucinations, only occur during the manic or depressive stage. The mood symptom has to be there. So you take away the mood symptom if they're still psychotic, it's delusional disorder or schizoaffective disorder if they have other severe symptoms of a thought disorder.
Did you review Dr. Flores's report in this case?
I did.
Did Dr. Flores at any time diagnose this defendant with a delusional disorder? What you're talking about, the first portion of your answer.
She did not.
Okay. Does anybody, to your knowledge, ever diagnosed him with that kind of delusional disorder?
No.
All right. So when Ms. Sampson was asking you about the delusional disorder and the definitions as they are in the DSM-5, does that have any relevance to somebody who is diagnosed with or experiencing symptoms of bipolar 1 with psychosis?
Well, there are two different diagnoses.
Okay.
So the bipolar 1 with psychosis would be psychotic during the mood episode.
All right. If someone has bipolar 1 with psychosis and they are experiencing a delusion, do they ever have a delusion if they don't also have the mania?
Or depression. No, they would not. That would either be delusional disorder and not mania, or it would be a schizoaffective disorder if they have other symptoms of a thought disorder, such
right.
as disorganization.
Okay, so I said mania. It could be mania or depression, way down,
Correct.
other end of the extreme.
That's right.
Okay. So could somebody be walking around experiencing bipolar 1 with psychosis, the delusions that are associated with that, what Dr. Flores said he has? Could somebody be walking around like that without experiencing these extreme emotions, either severe mania or severe depression?
They would have to have the mood symptom to have the psychosis.
Okay. All right. Thank you, Dr. Huey.
You recross?
Yes, Your Honor.
You may.
Did you review Dr. Flores' test protocols?
I did.
And was there any problem with her scoring?
No.
And the MCMI is a computer scored test, correct?
It was computer scored.
And the other two follow a scoring protocol, correct?
That is correct.
Let me just show you what was previously shown to the jury. This is a chart from the Mayo Foundation. Does that accurately reflect the moods or the variations within bipolar disorder?
It is a scale of the poles, yes.
Okay. And is that a chart you've seen before?
I haven't seen that particular chart. I've seen similar charts.
Okay. But it does accurately reflect the moods that you see in bipolar.
It shows the range, yes.
Thank you. Nothing further.
Any redirect?
Yes, sir.
Lawyers, may this witness be released and excused from the subpoena, and you want him to remain on the subpoena.
Maybe released from the state.
Any objection?
No objection.
You're free to go.
Thank you, Your
Good
Honor.
afternoon.
Yes.
All right, next witness.
May we approach your honor?
Sure, come on, lawyer. All right, ladies, let me step into the jury room for a brief moment. And also, you can send out a note how late can you go today. Just give it to the deputy here, pass it on. I may or may not honor it, but just write down how late can you go. All right, Lord, Gordon, you have a seat. All right, I just early. Here's out. Who's the next witness?
Yeah, the next witness is a major from the jail to authenticate a jail call that the defendant made that was served on the defense line.
All right. And is there no objection to this telephone communication?
There is, Your Honor.
What's the objection?
In this jail call, it goes to sentencing. He talks about what would happen if he were found not guilty by reason of insanity. He makes a comment about a few years in the hospital. That is not, first of all, that it's not appropriate for the jury to hear testimony about.
This not listed that. Go ahead, I'm listening.
About sentencing, about what would happen if he's.
They said they didn't want to think about it.
Go ahead.
If he's found in GRI, I was prevented from getting into that earlier.
You were prevented from what now?
From getting into
to what?
testimony about Georgia Regional and what happens with people who are sent there who are in GRI. It is an inappropriate comment on sentencing. It is outside the preview of the jury, so we would oppose it for that reason. If it is allowed to come in, then I would argue that it opens the door and we should be able to put up expert testimony about what actually happens if you are found in GRI.
Okay, yes, ma'am. What allegedly is in this jail call?
The jail call, Your Honor, or the 20-minute call, the state is interested in about 2 minutes of it. In about that.
Now, the 2 minutes that you want to play, and they may or may not want to play it in entirety, I assume if I decide I'll let it in, does it make reference to what she's referring to?
Yes.
Okay.
Insofar as the defendant voices an incentive to malinger symptoms of mental illness in order to gain. He tells a story, and he says that he, after witnessing something about an individual who is exhibiting obvious symptoms of mental illness, Mr. Neuman says in the jail call to his sister that he then remarked to his attorneys, better a few years with guys, I'm paraphrasing, better a few years with guys like that than the rest of my life with gangbangers and hardened criminals. That obviously is relevant to the defendant's motive and incentive. It is a voice of incentive to malinger symptoms consistent with the state's
When was this alleged call made?
The 4th of August after jury selection.
Of this year?
Yes, sir.
Oh, okay. Oh, 2016, I thought.
Yes, sir.
I see. Oh, okay. Is there a transcript? Did I ask that already? Is there a transcript?
No, sir.
All right. Anything else for the record?
No, Your Honor.
All right. If you lay a foundation, I'll let you play that.
Thank you,
It's
sir.
in your property.
And
Now, objections, brother. Are you planning on playing this in its entirety for 20 minutes or?
No, Your Honor. The defendant spends much of the call talking about trial team or trial strategy for the defense, and I don't think that's appropriate to play. The state's only interested in the 2 minutes.
And you said there's no transcript? Okay.
Type one out for you if you want.
You may have overnight to do that. Because someone knows where to start this, because I don't
Yes,
want
sir.
any reference to any conversations that he may or may not have with his lawyers present or past.
Yes, sir.
Anything else on that issue?
No, sir.
Yes,
Your
ma'am.
Honor, I would oppose just playing the last few minutes as opposed to the story that this is a part of. I mean, I would agree
Well,
comments
now-
about his conversation with his lawyers aren't appropriate, but based on the questioning, I will allow him to lay the foundation on the length and time, but yeah, I understand what you just said, but now I'm going to let her play that portion if it's admitted and it'll be admitted in its entirety. Now, if you make the decision on cross to play this in entirety, that's your decision, but I think it's appropriate, based on what I'm hearing on the proffer, for her to carve that portion out. Because what she's telling me, based on the proffer, it is not necessary for her to make any reference to any conversation he may or may not have with his lawyer. That can be carved out. But if it's only a conversation where she's partnering with his sister about his view, I'm going to let that part in. Now, as I said, it'll be in. If you want to play it in its entirety, that's your decision. But it's going to be your decision. All right. Lawyers approach before Constance.
All right, well. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in the seat. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in the seat. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in the seat. Come on in, ladies and gentlemen, make yourself comfortable. All right, everyone's present and accountable. You may have a seat, lawyers and parties. All right, ladies and gentlemen, let me go ahead and let you go for this evening. When I let you go with the assistance of Deputy Lewis, he's going to give you your communication advice. So do not discuss the case. I'll allow anyone to discuss the case with you. If you do decide to have a meal here in downtown Decatur, do not sit next to anyone who may or may not be discussing the case. Just either A, tell them who away from you or B, who away from them. Do not remain upon the fifth floor because I don't want you to know anyone you should not interact with or anything you should not hear. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do the research about this case. Do not blog or write about this case while it's ongoing. Do not go to any location that may or may not have been made reference to. All the evidence must come to you in the form of sworn testimony from this witness stand and on any stipulations and on any evidence that's introduced during the course of the trial. You're more than welcome to bring something to snack, if you do it in the morning and afternoon session. You're not consuming alcoholic beverages during the lunch break. And if you do decide to indulge this evening, do not overindulge. You are adults. You can consume alcohol if you wish. When you come back tomorrow, if you could, make sure you turn this communication device in the off position so they will not be buzzing or going out during the day. Lawyers and parties cannot talk or interact with you. And going to be on recess until tomorrow morning at 9 o'clock a.m. You can be early, but you can't be late. Just leave your notepads there in the jury room, turn them face down, put your numbers on them, and Deputy Lewis and Deputy Gilbert will provide you with more notepads if you need them. I will see you tomorrow morning at 9 o'clock a.m. Wednesday. If you're early, but you can't be late, have a good evening. Drive safe. And thank you for having such a positive attitude and keeping an open mind and following my instructions. And thank you for being on time this morning. And thank most of you for turning your phones off. On one phone I don't know who it was, but most of you at least turned it off, and I appreciate you doing that. See you in the morning. Drive safe. I think it's 25% chance of rain. Plan for that. Have a good evening. All right, lawyers and parties, you may grab a seat if you wish. All right. Lawyers, approach this briefly.